Welcome to Holistic Accountant Podcast, where we aim to showcase how adopting a holistic approach in accounting and tax maximizes value for clients. Beyond traditional tasks like preparing financial statements and tax returns, a holistic accountant focuses on offering advice that maximizes personal wealth on an after-tax basis. If you enjoy this episode, please consider leaving a rating and sharing it with those who might also benefit. And to ensure you stay updated, subscribe to our weekly email. The link is in the show notes. Okay, today Mena and I would like to talk about perhaps something that's inevitable or statistically inevitable for a lot of people listening to this podcast, whether you might realise it at this stage or not. I don't want to be really negative, but...
Got to say, very optimistic of you, Stuart.
I know, it is a bit negative, isn't it? But the reality is, statistically, marital separations, particularly in our business post-COVID, there's been a notable increase in it, which is why we're sort of talking about it today. But what we want to talk about is really what can you do to get at the front end of it, like in terms of minimizing your risks to deal with the statistical risk of a relationship breakdown. So, let's think about if it was to occur, what actions could you take today to, better preserve your wealth and hopefully make that situation easier to navigate. And then secondly, which I think most people probably fall into this bucket, is what, if it comes upon you, unexpectedly, of course, what are some of the things or steps that you need to take to sort of work through that as a business owner?
So we'll work through the first section as to, if you're starting a new relationship, what you should do or what you should expect, or even if it's a newly formed relationship, what steps you should take before you sort of undertake the relationship any further. And no one sort of plans to start a relationship to plan for it to end. So some of these items could be difficult conversations to have with your partner, but they are extremely important because, like I said, we've seen clients give up to 60-70% of their wealth away, after a separation, and pay hundreds of thousands in legal fees as well. So, if you try to protect your interests from the start, it can go a long way. So the first thing is a BFA, or a binding financial agreement. So this is basically what is commonly referred to or known as a prenup, what you hear on TV shows and movies, but here in Australia is known as a binding financial agreement. This is where it basically stipulates whose assets are whose prior to a relationship. It sort of sets a benchmark as to any sort of assets that are required after the relationship, how they should be split up, and who's bringing what to what the relationship as well. It's really important to get a reputable family lawyer involved in this, not a general lawyer, just because, as in any industry, everyone has their own specialties, and family lawyers specialise in BFAs.
And also, there's a couple of things to point out. You can also have a post-nup agreement, so a BFA after you've married. You can do it any time. The best thing to do it is before you would be considered a de facto relationship, which typically is around the time of cohabitation, although it could be different in different circumstances. So the sooner you do it, the better you are off, the more enforceable it's likely to be. That said, if you were a couple of years into a serious relationship, of course you can put a BFA together at that time as well. The second comment I'd make is that you can shop around in terms of prices to put these agreements together, and decent agreement. So of course you can pay almost whatever you want. There's some lawyers out there that would charge a huge fee to put these things together. That's not necessary to pay that. But shopping on price, you've got to be careful on that as well. At the end of the day, a BFA is costly to put together, but a good one will save you a lot of money in the event of a marital separation. So I tend to quote around $10,000, should cover your legal fees and your partner's legal fees. You'll draft the BFA typically, and then your partner will need to get an independent lawyer to sort of sign it off or give your partner some advice to make sure it's suitable for their circumstances. And I say budget for $10,000. A lot of people have indigestion when they hear that fee, but the reality is that if you want the lawyer to spend some time understanding your situation and drafting it correctly, as I said, in the long run, in the event of a separation, it's going to save you a lot more than that. The other factors to think about are, structuring your business affairs. And the primary thing here is maintaining control throughout a separation. So a lot of separations are pretty acrimonious. They can turn really nasty. They can be prolonged and take anywhere from 1 to 5 years to resolve. So you can kind of be in a holding pattern for a period of time, and it's really important that you're able to make decisions and manage your business throughout that time. So making sure, who the appointers are in a trust, who are the directors are of trading companies, shareholders, beneficiaries, beneficiaries, trustees, all these elements that go into, the key roles around your business structure, trying to make sure that you've got control over those entities so that you can keep managing that. And another thing that we've learned through experience is even ownership in properties. So we had a client that separated a few years ago and he was the only person on title for his home and the family home was being sold, but he could control that process as in make some really logical and well-informed decisions. And his partner at the time wasn't necessarily in that headspace. So that was a really good thing from our perspective that we were able to help our client maximize the sale price without necessarily his spouse intervening and retarding his ability to do that.
And just to add to that, it's not only about control as well. Also, when it comes to beneficiaries within your trust deed, it's really important to think these clearly. Sometimes it's not always a good idea to note your partner down as a beneficiary of your trust deed. The reason being is post a separation, when you want to remove them as a beneficiary, it can cause a resettlement of the trust deed. What that means is it's taken as if you've basically sold everything and purchased it again. So you could be up for a capital gains tax bill. So generally, partners, spouses, family members, and so forth already form part of your general beneficiary clause as part of the trust deed. So sometimes it's just best to note yourself only as a beneficiary and just keep them as a general beneficiary rather than naming them as a specified beneficiary. Now, the third thing that you should consider is whether your partner should obtain their own sort of financial, legal, and accounting advice, I should say. The reason behind this is that when a separation happens, there could be a conflict of interest in terms of the advice given if your accountant, financial planner, or lawyer acts for you both. So consider whether you guys should have separate affairs from the start. That way there's, everyone's looking out for their own best interest and the advisors have no conflict going forward.
It's a really good point, Mena, because if a client comes to us and let's say the husband asks, how do I structure things in the event of a separation? The problem is that we've got a conflict of interest because maybe the husband and wife in that situation are both our clients. So we can't really provide advice that's in one person's favour. Whereas if the husband was just our client and the wife had another financial advisor and tax agent, well, we can go hell for leather in terms of saying, well, we need to take all these steps so that you've got the maximum amount of protection. So it's a really good observation, Mena. All right, so let's change gears a little bit. And, there are all the things that you could do and there could be more. So, of course, you should be speaking to your advisor and holistic accountant. But what are some of the things that you need or steps you need to take, considerations you need to take into account if your relationship dissolves and, it's beyond repair and you both decide that a separation is the best way forward? So, of course, if you're in business, your business, as in the value of your business, will be part of the matrimonial asset pool, and a lot of circumstances will be a significant part of that asset pool, or could be at least. You as the business owner hopefully will want to retain that business potentially, and therefore your goal would be to minimise its value, whereas of course your partner's going to want to maximise its value. And the problem with that is that business valuations are pretty subjective. It can sort of go each way. I mean, there's things and arguments you can make in terms of, the goodwill rests with you, the business owner, the person that started the business, the person that's managing the business. You might have key personal relationships that aren't necessarily reflected in, contracts between your customers and suppliers and your business entity. And so that needs to be taken into account. The reality, though, is that the business, particularly if it's profitable, is likely to have some value. It's not going to be zero. It might not be a huge value that your ex-partner is suggesting, but it's important to sort of understand how valuations are put together and try to come to some sort of agreement. I typically try to counsel clients to try and reach an agreement as soon as possible. The reality is, at least from what I've seen, is that the longer the amount of time elapses between when you decide to separate, the greater the probability of disagreements arising. So if you can strike a really quick agreement within the first few months, if possible, you should absolutely do it. Because if you don't do that and you don't have an agreement 12 months later, chances are you're in for a bit of a fight. And so keep in mind materiality as well. No point arguing over a $50,000, $100,000 difference in the business value if that's the impediment in order to get an agreement from your ex-spouse. The reality is that firstly, you might end up having to pay for an expensive valuation and that valuation might come in at a much higher figure than what you might anticipate. Notwithstanding, you're going to pay a lot of legal fees on the way to get to that point. So I would just encourage people, striking a deal, it's got to be fair, of course. And when I I say fair, a fair deal in a family law matter is when neither party thinks they've won, when neither party thinks the deal is fair to them. That's probably the likely scenario where you've reached a fair deal. So the business value is probably going to want to be the big issues, and it's something that you're going to try and need to tackle, and you want some experience on your side. So certainly your accountant and, of course, a family lawyer can help you with that.
The next thing to consider, and sometimes gets overlooked, is taxes. Now, when you come to dispose of certain assets, and we'll go into availability of rollovers afterwards, but sometimes when you dispose of certain assets, there's got to be tax consequences to deal with. So having an allowance in your financial split that determines, okay, by me giving you, this property or this business or these shares, I'm going to be up for a $500,000 tax bill, that needs to be factored into your financial split, because otherwise, it's just going to come as a nasty surprise afterwards.
Yeah, all unrealised capital gains should go on the balance sheet to determine the marital asset pool, so they should be a liability. And just speaking about business valuations, that's one of them, right? If you're going to keep the business, if you go and sell the business down the track, you're going to be up for capital gains tax most likely. I mean, you might be able to use some exemptions and so forth to minimise that. But that's one of the arguments you can make as the person keeping the business to reduce the effect of increasing the asset base, is that you need to include any capital gains tax liability that sort of rests with that valuation. If your business is worth $2 million and you went and sold it tomorrow, you're going to pay some CGT on that $2 million. And that's true for investment properties and share portfolios. Any other assets, you should include a provision for capital gains tax. Now, of course, that doesn't necessarily mean you're going to pay capital gains tax. There are plenty of CGT rollover concessions that accommodate marital separations. So that can include, obviously, transferring of real property from joint ownership or tenants in common to one person if they're going to keep that property post-separation, transferring of other assets, other investment assets. It can include transferring of assets out of a family trust or a company into one of the spouse's personal names. Unfortunately, you can't go from a company trust into another company and trust, but you can go from an entity into a spouse's name to get the rollover. And then superannuation splitting is another thing you're able to do in terms of split balances as a result of a financial agreement.
Now, the other thing to consider is more from an operative side of things. Obviously, a relationship breakdown can be really emotionally daunting, and you might not be able to go into your business and operate it as you once did until all the dust has sort of settled. So it's always good to have an idea or a plan of who would step in should something happen. And this is a general sort of guideline anyway, because if you become incapacitated or have an injury at work and you can't operate the business, it's always good to have a backup plan. And this backup plan should also come into play in the event of a marital separation, just because you're not thinking clearly, you're highly emotionally charged, you're not probably going to be making the right decisions. So having someone to step in and have those conversations and make those decisions for you will provide some significant benefits.
I've personally been through a marital separation and managed a business through that process, and I can certainly confirm what Mena's saying is correct. If you've got a good relationship with your ex-spouse, that's fantastic. But as I said, unfortunately, a lot of them don't turn out that way. It can be very acrimonious. And what you might not realise is the amount of time and energy, particularly emotional energy, but also time that you need to contribute towards dealing with the financial matters and the agreements and the communication between the lawyers and all those sorts of things. It's almost a job in of itself at times, and that's going to take you away from your business. So there's something to really think carefully about. Finally, of course, if you are in business with your spouse, I guess we can add, a factor of 2 or 3 in terms of complications and additional challenges. Hopefully you've got the right agreements in place to sort of deal with that, which could be a buy-sell agreement, which might suggest that the trigger event is an agreement to separate, that one party has to buy the other share off the other party, or shareholder agreements or unit trust, unit holder agreements might also dictate, what happens in the event of a separation. If you don't have those agreements in place, well, then it can get really messy potentially, and it's something that you really want to engage an experienced family lawyer on and your accountant together in order to sort of come up with a plan to sort of navigate that. And I guess the primary objective firstly is the operational control over the business until a financial agreement is reached, and then obviously, one party either taking full ownership or potentially selling the business to a third party. But there's some of the factors that you need to consider if you are unfortunate enough to go through a relationship breakdown. But I think there's some really good key learnings in there for people that are in very happy relationships. As the saying goes, or to some extent, plan for the worst, hope for the best. And so there's some steps that you can put in place at least to make it easier, ultimately potentially for everyone. If you can reduce the elements or the potential conflicts that could arise in a separation, then arguably you've got maybe it's smoother sailing to reach an agreement. Okay, that's it from us for this week. Until next week, bye for now.